Good morning. Actually, this case, though very complicated to understand, but I refer this case for the purpose of understanding certain situations wherein the land promoters used to purchase the land from available legal heirs, ignoring the other legal heirs, and due to their muscle power and political power and the registration office and the revenue authorities power try to gain over that. Apart from that, this case also slightly make you to understand how the Muslim succession laws divides the shares of the property. See, case of kindly go through the judgment once, twice, thrice to understand all these concepts. AR 2022, Guwahati, page 13. Jaidul Islam and another Abu Sharma versus Abu Sharma. It's a case where specific relief act section 34, relief of declaration and possession. The plaintiff claims he purchased the property from co-sharers. Defendant counterclaim that he purchased same from co-sharer. Alleged vendor of plaintiff admitting that he is not aware about her share of land from her father. Neither she or her husband ever occupied any land in village where the suit land is situated, and she executed sale in other village as per advice of plaintiff and never delivered possession of land to plaintiff. Plaintiff failed to prove title of his vendor to suit property. Plaintiff not entitled to relief. Then they say transfer of co-owner. Alleged co-sharer not having any saleable right in suit property. Sale is invalid. Transfer not entitled to possession or enjoyment of property purchased by him. Then other things are there. Section 48, 46 of the transfer of property was discussed. That two provisions also a little bit complicated to understand. See, these things are there. Actually, you try to understand that only this area I would like to share with you. Sahib Haji Ali has 2 wives, 8 sons, 5 daughters. Then he left 2 bigha, 2 kathas and 6 latches of the land. Actually, they say, as per principles of Muhammadan 2 wives entitled to 1/8 share. Each son was entitled to double that of each daughter, and consequently 2 wives would get 1 katha, 10, 6.8 latches. Each son would get 1 katha, 10 bar 21 latches from the said disputed dag. Under such circumstances, the daughters had no saleable right over 2 kotas, 12 latches of the land as described in the schedule. So this is the case which these daughters do not have a right to sell, seems to have sold the property. Therefore, they did not, they could not succeed before the court. Another aspect, it is also most important those who are pursuing judges' examination, how this issues were framed. You see how issues were framed. Whether the cause of action for the suit is there, whether the suit is maintainable, whether the suit was undervalued, whether the suit is bad for non-joinder of necessary parties, then whether the plaintiff have right, title, interest and possession over the suit land, whether the defendant have right, title, interest over the suit land described in Schedule A in the counter claim, whether the plaintiff are entitled for degree as paid for, whether the defendant are entitled for a degree as paid for in the counter claim, then to what relief the parties are entitled. This is the issues. The substantial question of law before the second appeal was whether the courts below committed error by dismissing the plaintiff suit, holding that vendors of the plaintiff who were co-sharers of the suit land had no title and right to transfer their shares in the land by executing registered sale deed as co-sharer. Then whether the said vendors of plaintiff, in view of the provision of section 44 and 48, are permitted to take plea that they had no title over the suit land at the time of execution of sale in favor of the plaintiff. Any other question of law? So these all are how to frame question of substantial question of law. Unless and until you frame substantial question of law, you may not be in a position to get your second appeal admitted. So kindly go through that.